Good morning, Leah. Sorry, that's totally on me. I didn't text you on Friday when we got it. I was super busy. I know because you said Thursday they didn't assign us a jury trial, but they dropped this one on us like. Good morning, Leah. Sorry, that's totally on me. I didn't text you on Friday when we got it. Why is it repeating? I know because you said Thursday.
I don't know.
Oh, that's the YouTube. That's the YouTube. Hang on, I gotta shut the YouTube thing off. That happens all the time. Here we go.
Okay.
There we go.
Can you hear me?
I can hear you. I keep forgetting we have to do it live on YouTube. So sometimes when we put it on, I forget to mute it, so it goes through twice.
No problem. I'm gonna dial in on my phone too, just for redundancy in case this Wi-Fi gets wobbly. So
all right.
You'll see me asking to be admitted again.
Sure. Yeah, we gave Mr. Jensen a few minutes because obviously you weren't here and we were just continuing for 30 minutes or so. He'll be here shortly. He's in another courtroom.
No problem.
All right. All right. In the name of the Commonwealth of Pennsylvania, this court of common pleas is now declared open. Judge Glynnis, help presiding.
Hi, Judge.
Hey, Judge. How are you, Eric?
You haven't aged at all since the last time I saw you.
Oh, I wish that were true. You're saying that to make me feel good because when I see people now, oftentimes they will say, hi, sir. You start to get more and more of that now. So,
I'm paying extra for the color of my hair. What's up with it?
And then I was with my wife Friday, and we were together actually, getting our COVID shots.
Sure.
And,
yeah, I got mine.
The person who was with her asked if I were her father. So.
Oh my goodness! My goodness! My goodness!
They thought she was my daughter. So I wish all that was true, but you got your brownie points in for today, so that's a good thing.
There you go. This is going to be a very simple case moving forward, Judge. It's just
anyhow, good seeing you. And I'll just for the record, Eric and I went to law school together. It seems like it's hard to believe it was all those years ago, huh, Eric?
40 years plus, Judge.
Yeah, but thank God we're still here.
That's right. And I'm very grateful for the opportunity to be here today. Yes.
Yeah, likewise. So go ahead. I want to turn the floor over to you. It looks like is your client present as well?
Yes, she's here.
Okay. And looks like the defendant hasn't appeared, right?
No, he's been a dog the entire time, respectfully said. I mean, if the testimony would be taken, it would show that the parties were married on January 27th, 1990. They bought 2015 South 11th Street on 16 October 1995. They got divorced on September 21st in 2018. That's what the evidence would show. And that despite his promises to put the property up and list it for sale, he's refused to do it. My client has incurred $5,000 in legal fees. So we're asking for an order for a petition for my client to be given exclusive authority to sell the property, that the proceeds be split after cost 50-50, and my client be reimbursed for $5,000 for the cost of having to take this all the way through trial at this point.
Okay. Well, in a minute, I'll still, your client, you said is here, right?
Yes, she's willing to
Yeah,
testify.
so you, obviously, you gave me a nice synopsis. I'll consider that as your opening statement if you want.
Yes,
And,
absolutely.
but she'll have to put something on the record as the actual witness, and she'll
Uh-huh.
have to be sworn, because obviously
Sure.
your statements are not evidence. So,
Understood.
so in a minute, you can swear her in and just make a quick record.
Yep.
And then I did have one question for you. And rather than ask later, I'll ask now. With regard to the attorney's fee, given what the law is, and I understand your frustration, and trust me, off the record for a second. Are we off, Leila? Ms. Bloom?
She's off.
Okay. Yeah, off the record for a second. Obviously, I've known you and I understand your frustrations, and from that standpoint alone, if I legally could do that, I would grant the attorney
Understood.
fees. I just need to know a legal basis why you believe that I could do that. First of all, vexatious litigation, that's one standard.
Yep.
And yeah, go ahead. So what's
Well, mine would be that this is a court of equity, that she's incurred these costs, they're reasonable costs. This case has gone on for a number of years. It could have been settled. The testimony would be that his conduct would give rise to that level that would entitle my client to be reimbursed for those fees, because she's had incurred.
Excuse me 1 second. Ms. Bloom, you can put the Mr. Jensen's response on. I asked him basically why he believes, he would be entitled to attorney's fees. So I would like this on the record. So go ahead. All right.
Yeah, basically under court of equity, Judge, this litigation would not have been necessary but for the unkind conduct and the intentional willful conduct of the husband, ex-husband, in obfuscating and not doing what he promised to do. The testimony would show that he agreed multiple times to do it, then he didn't. Then the testimony would show that in the course of negotiations, he's treated my client very badly. He's basically constructively evicted her out of the premises by removing her bedroom furniture. And given all the facts that she would testify to, I think it would give rise to a level of conduct that would be appropriate to reimburse the attorney fees from his portion of the sale. We'd still agree to a 50-50 sale proceeds, because the fact that they're locked in as tenants in common under law since the divorce decree has been aired.
All right. And you $5,000, that's what you were looking for?
That's it. And $400 for court costs.
All right. How long has your client been trying to resolve this issue?
For over 5 years, Your Honor.
I see. Okay. All right. Well, thank you for that explanation. And having said that, we're going to swear your client in just for a second. You can make a very brief record, so we'll have at least some evidence from her on the record, okay?
Okay.
All right. So you want to go on?
Ma'am, could you unmute yourself?
Yes, I did.
Okay, can you raise your right hand and state and spell your name for the record, please?
Cindy Gordon,
Hold on, you're.
Go ahead.
CINDY-GORDON.
All right, do you swear that the testimony you're about to give to the court today will be the truth, the whole truth, and nothing but the truth?
Yes.
All right.
All right. Go ahead, Eric.
All right. Thank you, Judge. Cindy, would you please state your full name and please, for the record?
Cindy.
All right. And have you been married in the past?
Yes, to him, to my ex.
Okay. And who were you married to?
Lawrence Gordon.
Okay. And can you tell the court where he currently lives?
Yes, 2015 South 17th Street.
Okay. And is that property in both names, your name and his name?
Yes.
Okay. And am I correct that you were married on January 27th, 1990?
Yes.
Okay. And that's attached as an exhibit to the complaint, if I'm correct, and marked as exhibit. Let's see if it's in here or not. It might not even be in there. But that's the date you were married. Okay. And you bought this property, do you recall buying it on October 16th, 1995?
It was October, the exact date, I don't remember, but yes.
Okay, and that's a true and correct copy is attached to the complaint and marked as Exhibit A, correct?
Yes, are you talking to me? Yes.
Yeah, okay. And on that deed, just for the court notice on Exhibit A, it says 16th day of October, 1995, and it was recorded in deed book 280, page D 1047473, just for the court records. Now, Cindy, my understanding is that you're divorced from Mr. Gordon at this time?
Yes,
Okay, and the date of the divorce decree, do you recall what day that was?
September 18th, or I'm sorry, September 21st, 2018.
And that's copy, the true and correct copy is marked as Exhibit B in the complaint, is that correct?
Yes,
Okay, okay, and what are you seeking to have done today?
just to settle the property so I can sell it. Right now, I can't do anything with it because
You
he
have-
won't sign
I'm sorry, because what? He won't sign, you said?
he won't sign the addendum. We signed the actual contract. And now he won't sign the addendum.
Okay, so have you
This year.
retained a real estate agent?
I have, yes.
Okay, and so has he,
Excuse me one second. When you say he hasn't signed the contract, you're talking about the agreement of sale?
No, he signed that. He
Okay,
signed the agreement of sale. He did not sign the addendum
the addendum.
to put the actual market.
yeah, I believe what he signed was the permission for the real estate agent to have authority to sell the property. But there's no agreement to sell because we don't have a buyer yet without the addendum.
Gotcha. All right.
All right, and how long has he been promising to cooperate with you?
Well, since we signed the contract in November, like last year,
Okay, and before that, had you been requesting him to cooperate with you and sell the property?
yes, but he didn't want to.
Okay, who was the one who filed for the divorce? Was it you or him?
He did.
Okay, and after the divorce was granted, did he, or when he actually filed for divorce, did he make any promises to you that he would agree to sell the property?
No, he did the complete opposite.
Okay, so he never agreed to sell. Okay, got it. And why did you agree to the divorce?
Honestly, just to get it done and get it over with.
Okay, and after the divorce was done, did you make repeated requests to sell the property to get your equity out of the property?
I did, and or buy me out.
Okay, and did he ever agree to buy you out for half the property price?
No,
Okay, so who's living in the property right now? Okay, go ahead.
no, he didn't. But later on, I think he wanted to, but he can't because he can't afford to.
Okay, are you living in the property currently?
Yes,
Okay, and what are the conditions there for you right now?
I'm not very comfortable in my own house. The furniture was removed out of my bedrooms. Every night I came home, the bed was missing. Then the window treatments were taken down. The water to the shower and tub, so I'm not able to take a shower. He unplugged the refrigerator, so I have no food in the refrigerator. I can't refrigerate anything. He put little plugs on the washing machine, so he removed the hoses, so I can't wash clothes.
Okay,
He removed the toilet seat, but I replaced it with a toilet seat.
Got it.
It's just
and do you know why he's doing all these things? Has he told you
think-
why?
cool for me, so I'll move.
So he's trying to force you out of the residence? Is that what he's trying to do?
Yes,
I have no further
and
questions.
on top of all of this, his sister threatened me.
Is
Right.
this what? On
His
top of,
sister has threatened.
oh, it's
Oh,
just,
his sister's thing. And how much have you paid in legal fees approximately right now in our contract? Do you recall? If I told you that it was about
I don't know. I could've-
$5,000, would that be accurate?
Yes, that would be accurate.
And approximately $400 in cost?
Yes.
Okay.
You did tell me that, yes.
No further questions, Judge?
All right, just a couple quick questions, ma'am. How are you?
I'm
Yeah,
good,
sure.
how are you?
Go ahead, sorry.
All
Go
right,
speak up.
all right.
I'm s-
Sometimes, for the most part, I understood your testimony. Occasionally, there were times when your attorney may have asked you a question and you may have responded, and it was difficult to hear your response because both of you were talking at the same time. And then this Zoom system here doesn't help. So I just need to get a couple, clarify a few questions for the record. You keep looking over.
Okay.
Are you there by yourself? Ma'am?
I'm at my aunt's. I'm not at my property.
Oh, I see. Okay. All right. So you're the only one living in that property right now, right?
No, we both
Oh, you both are in the
in
property?
different rooms.
Pardon?
Yes,
All right. So you both live there.
yes, we are
You both live in the property.
in different rooms.
All right. Let me finish my question and then you respond. Okay.
Okay,
That way we're not over talking one another. All right. So you both live in the property at the time. Yes.
yes,
In different rooms. Yes.
yes,
All right. And you got divorced, I believe you said in 2018, is that correct?
yes,
All right. And you got married in 1990, is that correct?
yes,
All right. Is there currently a mortgage on the property?
no,
Are there any other encumbrances on the property that you're aware of? When I say encumbrances, I mean any
No.
other, all right. So everything's paid off pretty much, right?
yes,
All right, it's just a question of selling the property and dividing the proceeds. Is that correct?
yes,
Okay, good. No liens on the property or anything like that, correct?
correct. There are no links.
All right, great. All right, thank you. I think that's it for the time being. Hold on 1 second.
I mean, it's everything that's in her complaint. She's made up the claim, so.
Yeah. Okay, thank you, ma'am. I appreciate that. Eric?
You're welcome.
Yeah, excuse me for calling you Eric.
It's okay, Judge.
Attorney Jensen, let me.
It's all right. You can call me anything you want, Judge.
Yeah, everything is spelled out in your complaint pretty much, I see.
Yeah.
And what did I want to ask you then, before we end this?
Anything about receivership?
You mentioned in your, yeah, you mentioned in your complaint about, making a recommendation for a receivership and you making the plaintiff the receiver, right?
That's correct, Your Judge. We don't need one under the circumstances. I think she would be it then. Correct.
Yeah, you're saying, an independent receiver would not be necessary under the circumstances. That's what
That would be correct, Judge.
Okay, fine. Yeah, because in the few times I've dealt with these matters, usually if the parties were uncooperative, I've appointed like a master or something like that and let the master decide it. But of course, that can get more expensive. And I know you're concerned about minimizing costs given the circumstances, especially since there's no encumbrances on the property, no mortgage. And the parties basically seemed like the husband just wants to be, for lack of a better expression, difficult and, in terms of non-cooperative, in terms of
Yes.
other property. Is that correct?
Correct, Your Honor.
All right. All right. One other thing. I didn't ask you about this, but I made an assumption. I assumed that there was good service.
Yes, Your Honor. It's on the docket too. We have it.
Okay, just for the record, there was good service. And when was the defendant served?
That was back in July of 2020. It was filed on 21 July 2020.
And he never filed an answer either?
No, Your Honor, he was served on by the sheriff on July 12th, 2020.
All right, he never filed an answer, right?
That's correct.
All right, fine. He's not here today.
He
Obviously,
knew about today multiple times, Judge.
yeah. I'm just noting for the record that he's not here. Okay, one final thing. We're almost done. Any other questions before we? All right. I'm going to, would you like to add anything else before we terminate this?
No, Your Honor.
All right, I'm going to take your requests, all your requests under consideration, okay?
Yep.
And I'm going to try to get you an order out this week, or with maybe
Understood.
within the next day or two, perhaps. Now, one final question. Do you have a sample? You didn't include a sample order with.
No, would you like me to email one over to you, Judge?
Yeah, include a sample order if you don't mind, including all the your requests, and
Okay.
I'll take it under advisement and may modify it. Okay,
I'll send that. What should I email it or fax it to you, Judge?
you can email it.
Okay. What would that be?
What's the?
You can send it to my email address, sir. It's BRIAN.Stickel, STICKEL @courts.phila.gov.
Would you like me to repeat that?
Yes, absolutely. That first name was tricky.
First name is Brian, BRIAN.
Oh, Brian. Okay, got it. Okay.
Last name
Dot
is
Sickles,
Stickel, STICKEL.
STITLE.
No, sorry. STICK, like stick,
Oh, stick. Okay.
and then EL.
And he is Stickner.
No, sir, EL.
Oh, yeah, Stickler.
Yeah, you want to repeat it one more time?
I'll repeat it one more time.
Okay.
Sort of like my ex-wife. She was a stickler.
Oh, no, I'll repeat it one more time, sir. STICK, like a stick, like I hit
Yeah.
you with a stick,
Yeah.
and then just EL, like the Spanish for the
Got
gun, EL
At courts.
@courts.phila.gov.
Very good. You're in with an excellent judge there. I hope you have many good years of experience with him.
Already have, sir. Already have.
All right, well, Brian, Eric, always good seeing you. And like
Yes,
I said, we're
likewise.
going to jump on this. Great seeing you. Stay healthy, stay
Yep.
well. All right.
All right, I'll send this over to you today. Thanks a
All right,
lot.
thank you. Appreciate that.
Bye, guys.
Terminate
Cynthia, you
this.
were wonderful.
All right,
See you
take
now.
care. All right, see you later. All right, now. Good luck, ma'am.
Thank you.
All right, see you later. Miss Blum, thank you. We appreciate that.
You're welcome.
Yes. Sorry for the late notice. We're going to try to do a little bit better when we give you notice.
Okay.
I'm going to have Michelle try to reach out to you as soon as we find out that we have a hearing, okay?
I did almost get assigned somewhere else this morning, so
I'm glad you didn't.
yeah, we're pretty short staffed, so it's kind of more important than ever.
Yeah, I understand that.
Give us heads up, especially with weather and
Yeah. All right. Well, you're right about that. So thank
yeah,
you.
and your staff can text me. I don't mind at all.
Okay. Thanks a lot. All right. You have a wonderful afternoon and be careful.
And you all too. Yeah, it's gonna get crazy this afternoon.
Yeah. All right. Thanks.
See you later.
All right. See you later.
I'm going to go